Thank you, Linda. Thank you, Proactive Escrow, for putting this together. And like Linda mentioned, having the right connections, having people you can talk to is very, very important. I have people that I talk to all the time, even like I call Linda for questions, and having the right escrow by your side is very, very important. I've had cases where litigation happens just because the escrow is like, I don't want to deal with this, but they're in the middle of escrow. I'm like, this is your responsibility. You got to inform the seller of certain things. You got to inform the buyer of certain things, and Linda's very, very, very helpful with that when it comes to handling her transactions. So thank you, Linda, for having me here today. As Linda mentioned, my name is Dublas. I'm an attorney. I do probates, estate planning, and presentation here today will touch a little bit on both topics. Okay, we're located in Torrance, and all right. So these are the things we'll cover. Who needs an estate plan, right? The forms that are required in estate planning, and when you don't have that, what happens in probate, right? And so we'll get started. So anybody a lot of people need an estate plan, right? But if you have assets of less than $184,500, then you can, if somebody passes away, you can transfer that estate to an heir or to heirs with a small affidavit declaration saying this person has less assets, and you can just transfer it right over. Same thing applies with real property, right? If the property is less than, I believe is 184, it might be a little bit more, but you can transfer property over to your heirs, or the heirs can transfer it to themselves without necessarily going into probate. If you have complicated family matters, which everyone does, everyone has complicated family matters, especially when there's money involved and there's more than one kid or there's a prior marriage or second marriage, then it's very important to do an estate plan, and we'll cover some of the things there. Medi-Cal and Medicare, that's also important. So, for example, if you receive treatment through Medi-Cal, Medicare when you're older, like dementia, Alzheimer's, or even a tragic accident, right? And you get Medi-Cal benefits. If you pass away and the Medi-Cal rendered services, they're going to come back for their money, right? But unless you have a trust, you're going to have to pay for all that stuff. Or your heirs are going to have to pay for all that. And Medi-Cal will come back and charge the estate. All right, so the documents are included in a living trust, and we'll talk about the living trust first, and then what happens if you don't have that, right? So the living trust, you have the power of attorney, the pour-over will, you have the trust, the medical directive, and the deed to trust, okay? And I believe, let me see here. Okay, so the power of attorney, we'll start there. The power of attorney works while the person's alive, right? And it's for legal decisions. And it kicks in when somebody becomes incompetent, right? A lot of times I get people calling me and say, hey, my dad's in the hospital, he's very sick, we need to do a will, we need to do a trust, he's got property, we need to be able to make medical decisions for whatever reason the family's not in agreement as to what decisions to take, or what to do, right? So the power of attorney kicks in. And it's very, very important because you can handle real estate issues, you can handle bank account issues, you can do a refinance, you can do a lot of things with the power of attorney. But you can't do it if the person's in a coma or they've lost their ability to make decisions, right? Once that happens, then it's too late. You can't do the power of attorney anymore. Another big thing to remember is the power of attorney stops working when the person passes away, right? So a lot of people think that you have a power of attorney and that's going to work after death. It doesn't. You can't do anything with it after the person passes away. All right, and then you've got the pour-over will, and that will, basically what it does, it gathers everything outside of the trust and it puts it into the trust, right, to avoid probate. So for example, a good example of that is, let's say the person has a trust and has 5 bank accounts, but accidentally forgets to put one of those bank accounts in the trust, right? If that bank account is not in the trust, there's a very good argument to say that the person who had that trust intended it that way and didn't want it to go in the trust, right? But if you have a pour over will, it makes it a lot easier to catch it and put it into the trust and distribute it accordingly, especially if there's a lot of money involved in there. Yeah.
Does the pour over will absolutely absolve the estate of going through probate?
Well, you would have both, right? You would have the pour over will and you would have the trust.
Right.
If you only have a will, which is a separate type of will, you're going to end up in probate anyway. So there's different types of wills, right? Like you can make a will on your deathbed. You can make a will when you're anticipating to distribute your wealth, or you can have a pour over will. And a pour over will goes together with the trust. It has similar language so that it catches everything and it puts it into the trust, and then the trust kicks in to avoid probate. You don't avoid it just with the will.
So when you have a pour over will, and there are things that were left outside of the trust, do you have to make a declaration that it should be part of it, or is it automatic?
It's almost automatic. So the trustee of the trust, the successor trustee, has to do an accounting, right, to all the heirs, would include that in the trust. And if somebody objects, then you have trust litigation and things like that. But if nobody objects, then it allows you legally to just bring that asset into the trust and distribute it accordingly. But you do, through the trust, and we'll talk about that, a person has 180 days, so 6 months, to provide the copy of the trust to the heirs, and then the heirs have certain time to object to that trust or to the will, to any of the documents. And if they don't object within that time, it's called a waiver, right? And then you can't do anything about it. It just goes according to what's on there. But yeah, so that pour over will would help prevent probate of the entire estate. You wouldn't be able to use the affidavit that I mentioned earlier if you have a trust, if you have a home, because that affidavit is for everything. Everything is less than $185,500. Obviously, if you have a home, you have the bank accounts, it's going to be well over that. So you won't be able to use that. But the pour over will, it's very, very important. And it helps with lawsuits after death, right? If somebody dies in an automobile accident, the pour over will kicks in and you're able to file a lawsuit without having to go to probate first, get appointed, and then having a lawsuit that way. The other one is the trust, and that's obviously the most important document, right? And that controls, you're able to appoint who's going to be in charge of administering your estate. It doesn't mean that person's going to get anything, right? They're just in charge of transferring title to your heirs. And you're able to include whatever assets you want, such as your bank accounts, your real property, retirement accounts, so forth. And then we'll touch a little bit more on the trust because there's a lot more information on that. The medical directive, that's for medical decisions, right? So what happens a lot of times is the person's in the hospital and they have to, they're in a coma, have dementia, Alzheimer's. They can't do anything for themselves. And there's family members who are in dispute as to how to proceed, right? Whether they want blood transfusions, life support, they need to get certain medical treatment, right? There's people who say, I don't want to get, like if you have AIDS or cancer, like I don't want to get the chemotherapy because it hurts your body, but at the same time, it helps you prolong your life, right? So some people say, I don't want it, right? And so that's where you would put those decisions in there. You would say, I don't want life support, I don't want palliative care, things like that. And so I don't know if you guys ever heard the term conservatorships. And so that's when somebody obviously can't make their own decisions anymore. They have Alzheimer's, dementia, or in a coma. And so when that happens and you don't have the power of attorney or the medical directive, which is the first one and the fourth one on the list there, if you don't have those two, then you have to go to probate court, right, and get a conservatorship. And that is expensive. That is super, super expensive. And I'm sure you guys have seen it. The mom and dad are in very, very serious condition. They can't make any decisions for themselves. And now you get the kid who's like, oh, we need to sell the house, right? Because we need to take care of my mom. Or we need to do refi or reverse mortgage or something. And the parents, bedridden, can't answer any questions or anything. And they're like, well, we need a trust. I'm like, too bad. You're going to have to go to court and get a conservatorship. And to do that, it's going to be expensive. It's going to be very, very time consuming. And not a lot of attorneys do it because people who it's just like a regular litigation. So it's $400 an hour, $500 an hour, and people in those situations don't have the money to pay $500 an hour, right? So not a lot of attorneys do it. I don't know that many attorneys myself, and I talk to a lot of attorneys. So there's very, very few attorneys who take on those cases. They're super complicated. There's investigations that go on by the court appoints somebody to investigate to make sure that the person requesting the appointment is appropriate for this circumstance, that they're not going to steal money, right? And these are two separate petitions, right? Like, well, you can do one, but it's two separate orders. Like, you can get appointed for financial reasons, and you can get appointed for medical reasons, right? Just because you get medical reasons doesn't mean you get financial power over the other person. And to be able to get those, it's a very, 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 very high standard. You got to get doctors to say that this person's incapacitated, right? So imagine you're in that situation where you have your parents really sick, and they need to go. You need to take them to a doctor or do something to get two doctors to say this person's incapacitated, right? So now you got to take her to two different places, get a letter from that doctor to say this person's incapacitated. So all that being said, in short, if you guys call me, I have these two forms, the power of attorney and the medical directive. If you guys call me, I'll give you guys the forms, very basic forms for your clients, for yourselves, for your family, whoever you want. Just call me, I'll give you guys the forms. And you guys can fill those out and complete it. So at least at a minimum, get those two done, right? It costs nothing, just call me and I'll get it done for you guys. And that way you can avoid conservatorships, right? And like Linda mentioned, the more you know, spark those conversations, get those clients, you can give those to your clients, right? I mean, it's not legal advice. These are very simple forms, and say, hey, these are for your folks, if you need something ahead of time. And it works. Like, you get leads like that. Like, people who know more stuff get more leads and more clients. All right? Then lastly is the deed to trust. That's just the deed that we record we record with the property. All right. So this is what I was talking about regarding the trust. There is a revocable and irrevocable, right? A lot of people, and I'm sure you see this on Instagram and ever, like, oh, asset protection trust, and everybody goes for that. Like, it only applies in very limited circumstances. Like, if you're a business that knows you're gonna get sued, you're exposed to a lot of liability, then you say, fine, I get an irrevocable trust, right? Then you put your property into a trust. Once the property is in a trust like that, you can't sell it, you can't refinance it, you can't do anything. It has to stay in that type of trust, because the owners of that property, it's no longer yourself, it's going to be your kids, right? Or whoever you put down as a beneficiary. And so, yeah, you may not be exposed to liability anymore, but that risk just passes on to your kids. So if your kids get into trouble, right? If they get sued for something, then there's a lawsuit for them because they have future assets coming their way. So it's not a complete, absolute absolving of liability. It's just for yourself, and then it passes to your kids, but then it freezes that asset. You can't do anything with it, right? So it doesn't really apply. I've done one property like that, and it worked for them, but I highly discourage it a lot of the times. The other one is the revocable trust, right? And that one is what you get, most of the time. You can make changes to it. You can sell your property. You can refinance. The property remains in the owner's name as the trustee. The beneficiaries don't acquire an interest on that property until the husband and wife, the mom and dad, pass away. At the time of death, then that property becomes fixed. It's called cemented. And then, the heirs get it, right? But between that time, because you can sell the property and make any changes to it, it doesn't eliminate liability, right? A lot of people think that because you get a trust, you can't be sued anymore. They can't go after your house anymore. That's not true. They can still sue you. They'll just sue you in the trustee capacity. Okay, so what I recommend as well, what we do as well, is do the homestead. In LA County, that protects $600,000 of your equity. In San Bernardino, Riverside, I think it's like $350 of your equity. So what that means is, if you have $1 million home, right, and it's paid off, and they sue you, and let's say they get a judgment for $800,000 against you, right? Well, your homestead is going to protect $600,000 of it, and then the other 400 remaining are open for judgments. So, okay, so they can still go after part of it, but it protects a substantial part of your equity. If you have a home that's worth 800 and you have a loan that's 400, then the homestead would obviously protect that entire balance. So it's definitely worth having in there. If you don't have a homestead, you can always go in bankruptcy and they apply it there, the waiver.
Excuse me,
Sorry.
what
Go ahead.
is a homestead? Can you explain that?
Yeah, it's a document that we file with the county recorder's office,
Uh-huh.
and it basically says that you live in your home.
Okay.
It doesn't apply to second property, so investment property, any of that.
Your primary residence.
Right. It applies to your primary residence. And again, it's just a form we record with the county, and it protects a certain amount of your equity.
Okay,
Yeah.
thank you.
Yeah. Any other?
County sends it every purchase happens, transfer happens,
Uh-huh.
purchase transfer, county sends that document to the.
Yeah, I believe so, but I just
Yeah.
wanted to make sure I understood it.
Yeah, you gotta actually take it back to the county though and do it. And
Or
so
mail it, right?
mail it in. Yeah.
So I just have something to add. So on that form, there is an exemption that they send you, and you'll see it on your property taxes. So you'll have an exemption for so many thousands. That means that you've been filed as, that's your primary home.
On your taxes, you'll see it.
Yeah, you'll see. If you have that exemption, you filed that form at one time or another.
Okay.
Yeah,
Got it.
I think it's 7,000.
yeah.
So do you suggest to do that form even though you're not in any lawsuit or anything, just put it
Yeah,
in there?
because eventually, like I said, you can get that benefit through bankruptcy anyway, but then you would have to go through bankruptcy. So it helps protect a little
So
bit.
it's better to file it and then.
Just be
have it
proactive.
there on the.
Yeah, just be proactive with that. So that's that. This is the power of attorney and the medical directive that I mentioned earlier. If you guys call me, I'll give you guys those forms. Obviously, the forms that I use are a lot more extensive, a lot more detailed, but I have templates that you can have your clients or yourselves fill out. Like I said, the power of attorney and the medical directive, this will help avoid conservatorships. So it's very, very important. Because once you have this, and then the parents are sick or unable to do a trust, if you have a power of attorney and medical directive, this person can now create a trust for their parents, right, on their behalf. And so that would save you a ton of headaches, So if you get these two done at a minimum, later on when the parents get in a bad condition, you can create that trust for them. Okay.
I have a question.
Yeah.
I'm sorry.
Sure.
Power of attorney and advanced healthcare directive, does that also work for a child who's disabled and over the age of 18?
No, because you got to do these forms before the person becomes disabled, right? So if
What if they were born disabled?
yeah, so then you got to go to conservatorship. If they never had the ability,
Conservatorship?
yeah, if they never had the ability to give consent, then you have to go to court, right? These two are done when the person is fully capable of giving consent,
And competent?
right?
Okay.
Once that passes, right, if comes a point where the person no longer is able to give consent, then these forms are no good, right? And that's what I'm saying. Like, I get a lot of calls from people who say, "Hey, my parents in the hospital. Can you come do a trust?" I'm like, "Well, that depends. Is it a broken leg or is he completely gone?" Like, And so yeah. So get these two forms. Like I said, you just email me. I'll get you the forms. No problem. All right, so now probate. So assuming you don't have a trust, assuming you don't have any of the documents I just mentioned, and a person passes away with assets, then you end up in probate, right? And so even if you have a will, if you only have a will, you end up in probate anyway, right? Because people somehow magically draft a will like a few hours before they die, and so you can imagine how that can be questionable. And so if you get a will, you have to throw that into probate, and the court has to determine whether it's valid. Also, you have to determine who are the heirs of this person, right? I just recently got a case where this girl was taking care of a man, and he passed away, and supposedly the guy didn't have any family, so we filed a petition on her behalf, right, saying that she was closest thing to him. Somehow we got 15 cousins. Like, we have an opposition now, and there's 15 cousins out there who are objecting to her petition, right? So it's going to be about it. We have documents in support of her case saying that he wanted everything to go to her. But that's what the litigation is going to be all about, right? Whether that document's valid. But somehow these family members come out, and there's companies out there that they know when I filed this petition, right? They know that this person had no heirs because we mentioned that in the petition. And they go and find the heirs. So that's how you get all these family members, right? They go and find the heirs, and then they do it for a share of the estate. So that's quite a big step there. And then step number 3, once you file your petition, and as you can imagine, let's say you have multiple kids, right, and they don't get along. One kid wants to get appointed over the other, and that's going to be a battle, right, because there's benefits to that. When the person gets appointed, you get to select the realtor who lists the house. You get to select the work that gets done on the house. You get to select the value that is eventually sold by. It's subject to other conditions. But you also get paid as the administrator. You get the same amount that I get paid, the administrator gets paid. And so it's usually about $15,000 to $20,000, $25,000 or so on each probate. So there's always big disputes on that. Always. And that's where all the nitty-gritty stuff, like this person's a fraud, they never cared for my family, they live out of state or whatever. A lot of dirty allegations come out there. And then eventually, once you get appointed, you have to sell the property, right? And so that's step number 4. And like I said, it all comes down to step number 3, who gets appointed, and then the property gets sold, and that's where you guys come in. Yeah, good.
And do they have to pay that upfront to the attorney or after it's sold?
It gets paid at the end. So always make sure, a lot of people out there, I've come into cases where the attorneys charge a fee up front, right? And you're not supposed to do that. Attorneys can't get paid until the court says it's okay and then gives an order, specifying the amount that the attorney gets paid and the costs and so forth, right? There's certain costs. Good?
No, go ahead.
Okay. There's certain costs that do have to get paid up front, like filing fee, publication, and a bond. Those 3 things have to get paid up front. But you don't have to pay that to me. You pay that to the bond company. You pay that to the newspaper company. You pay that directly to the court. So you never pay the attorney up front. And if you hear anybody say that, just stay away from that attorney. That guy's going to pocket the money and probably not close the case or something. So go ahead.
So all those costs have to be paid by the administrator, right, out of their pocket?
Yeah, usually yes. On some cases, I take on the cost. And so, but on other cases, I don't. I stay away from that.
But secondarily, how is it determined whether a probate is full authority or partial authority?
Yeah, so that's a good question. Let's assume that there are objections, but the house is in foreclosure, right? And somebody needs to get appointed to get this property listed. So in that case, the court appoints a temporary person, right, a special administrator, for a limited purpose of taking care of this house, so prevent it to going into foreclosure. Then after that, you still have the dispute, this number 3, and the court basically, you appoint that person temporarily, and you make them get a bond, do all that, but then you still have the full appointment that needs to be done later. And so it's an evidentiary hearing that takes place. So, yeah.
So is it the court that's appointing the administrator?
You both file petitions, right? Like I have a case right now where the decedent, he was married, and then there's a son with many other kids. The widow filed a petition, and I filed a petition. Technically, the widow has superior right to be appointed, right? So the court would normally appoint her. But my objection is that they got married at a time where the guy was completely incompetent, right? He couldn't have given consent to the marriage because he was long gone. There's plenty of medical records to indicate that. So I'm going to object and say she shouldn't be appointed because she obtained this marriage through fraud. And then hopefully if the court believes it, then my guy gets appointed and then we go through the entire process. But just that dispute will get set for trial. And I mean, this was filed last year, so we haven't had anything yet. So yeah, good.
How about if someone doesn't agree with, like for example, selling it, let's say,
Mhm.
and then he said, I'm not gonna sign anything. Can you go above that?
The
Or
one of the heirs or the administrator?
one of the heirs.
Oh, they don't have any say. They don't. Once this person gets appointed, that's it. The other person's they can object as to the value. They can object as to, I mean, that even then, like the value, because what it is, the court appoints a probate referee, right? He goes out and appraises the property, and their value is always low. Like if the house is worth $600,000, they'll put like 500 on it, you know, and so their value is always low. So then, as long as you sell above that, which it's going to be easy, you know, there's no challenge to that. As long as you sell above that, the heirs can object all they want. It's going to get sold. Like, and that's another thing too. People always think you're going to keep the house in probate. Like, absolutely not. You're just not. People they're like, oh, my dad wanted this house for the family. Like, well, too bad. You know, like unless you're going to pay off that mortgage, unless you're going to pay off the cost and all that cash, right? And then, so one heir can be like, okay, I'm going to buy this property, right? Well, you can buy it in the open market. Good luck, right? And so you don't get any special treatment because you're an heir. You're just going to buy it in the open market like everyone else would. So the property's definitely going to get sold unless it's paid off and you pay all the cost, right? But even then, you got to get all the heirs to waive their interest, which is highly unlikely. So the property's definitely going to get sold. Once the person's appointed, he gets to decide everything, right? And that's why it's such a big deal, right? Who gets appointed? And the court's going to appoint a probate referee who's going to appraise a house, and it usually gets appraised really low. So as long as you sell within that 10% of that, it's going to get sold. And then that money, all that money goes and sits in an account, right? And for about another year and a half, until we do all the accounting, we pay all the debtors, we pay Medi-Cal, Medicare, and then all that gets deducted. And especially if there's litigation in the trust, right? Probate attorneys love to litigate these cases because if there's equity there, man, we'll bill like $4.50 an hour and just fight people just for fun. And then, you know, then they get their bill, right? Not for fun, but I'm saying like it's a lot of things that you wouldn't even imagine the stuff that comes up. I'm fighting a case right now where the mom sold the house, put the money into the son and the daughter's property, right? Now, then the son died, and then obviously the sister is the owner of that money, clearly, right? Clear as water. So, but now I have an attorney who filed an A50 petition against my client because he wants that money, saying that money belonged to the deceased son. I'm like, no, it belongs to my client. She's, you know, right of survivorship, joint tenancy, all that. And he's billing by the hour. And now I'm going to bill by the hour, right? But his claim is so frivolous. That's what I'm saying. People file these claims and they love to litigate because they bill by the hour and they're going to get paid at the distribution at the end, right? So
If it's a frivolous claim, he shouldn't get paid, right?
no, not in probate. In probate, you can make a claim unless it's malicious prosecution. Those are different elements. As long as a malicious prosecution only applies if you have like 0% of an argument. In this case, there might be a little bit just because the guy was on title with the mom when she passed, right? But it's a far shot, but we have to defend it. That's what I'm saying.
There's two questions here.
Yeah, go ahead.
So the living trust can avoid probate?
Yes,
Yes.
definitely. That's the point.
My other question is that when you talk about this litigation and this process, what is the typical time, not when the person dies, but when they actually open up probate towards, you know, terminating that probate case?
Yeah. So the administrator, right? It's usually the person who's most responsible in the family because there's certain criteria you have to go through, especially if we have an evidentiary hearing on it. So you're going to have to deal with, as the administrator, you're going to have to deal with a lot of family members. On a recent case that I had, we had to evict an uncle who didn't have a place to go, but you know the estate needs to like move forward, and we need to sell this house, and the buyers don't want that tenant in there, so we had to evict the guy, right? I mean, it sucks, but he was just living. It was his mother who passed, right, and this son just lived for free in the house, and so he wanted to continue living there for free. I'm like, no, dude, I'm sorry, we gotta evict you. And the person who was appointed, same thing. I mean, they were all family, but there's only so much you can do, right? And so you got to deal with that along with the burden of taking care of everything else. So it's a huge responsibility, and that's why the administrator gets to charge extraordinary fees.
I have two questions.
Uh-huh.
One,
Going back where you say that an attorney could frivolously, take their time, I think what you mean, I worked for lawyers for 10 years. It's just with attorneys, they either could take the shortcut and really take care of their client, or they could take the long route, and
Yeah.
that's where he's saying.
Yeah,
So-
I don't mean frivolous, definitely
Yeah,
not frivolous,
I think he means that
but,
they could decide to make it a little more, because they get paid,
Yeah.
so be aware of that.
right,
Two, I really would like everyone here to understand that when there's a listing and they offer onto that listing that's a probate, and then it goes to court and you can overbid on it. Because a lot of agents I've noticed that they think, okay, it's already an escrow, or it's gonna be an escrow. No, you still have the opportunity to go and bid. right?
yeah, and a special administrator. If you have full authority, you don't need the court's approval. So when you have limited authority, that's when you go to court, and then there's an open bidding for it. But when you have general authority, as long as it gets put in the market, you don't need the court's approval for
You would ask
that.
that attorney, or, because I know the agents sometimes kind of, I might lie about that. So how do you find out if is there a public record on that?
Yeah, you can look up cases by the name of the party or by a case number, right? And then these documents are public, so you'll be able to see whether the court appointed somebody with limited authority or with general authority. And then you'll be able to see the department, you'll be able to see the dates when the hearing will take place, and so forth. So,
Thank you.
yeah,
Thank you.
you're welcome.
What criteria, again, does the court use to determine full authority or limited authority?
So like I said, if there hasn't been an appointment yet, an actual appointment, but the house is in foreclosure, and so and there's no one appointed, right? But the house is in foreclosure, something needs to be done about this, and that's when they appoint a special administrator just for this purpose, just to sell the house or prevent it from going into foreclosure. So it doesn't, not necessarily just appointment for sell a house, but appointment to save the assets, right? And so that can be a number of things. That can be refinance, that can be renting the house, collecting the rents to pay the mortgage. That can be a number of things. So it doesn't necessarily mean selling the house. And the court can tailor those orders too. So it can say, hey, you're given authority for this house, but you're not allowed to sell it. Right? If you want to sell it, you have to provide notice, and then we'll have a whole hearing on it. So there's many things, but that would be one example of it. So,
But if you're in foreclosure, you cannot refinance the property.
correct. So there's different circumstances, right? Like the property could be paid off, but somebody's taking the rents, right? And so the court can appoint a special administrator for that purpose to collect the rents or to evict these tenants, right? So something like that. And there's many different circumstances. I think I saw somebody's hand there.
Regarding disclosure on full authority or limited, we can't keep it vague. It has, we as agents have to disclose that, right?
Yes. Always, the more you disclose, the better. Always.
But the administrator cannot limit that information, for example, keep it, you can't disclose.
On the listing?
Regarding letting them know whether it's full authority or not. Can someone tell you not to?
It's not recommended, and especially if you're in contract to sell the house, and let's say you go 30-day escrow. There's no way you're going to close in 30 days. You got to go to court, and you got to get a hearing date and all that. So there's no way you're going to. So then if you don't disclose it, then you're in trouble, right? Because you got to close. Let's just say the seller's ready to close, but the buyer's ready to close, and the seller can't close because they have to go to court. So now you're in trouble, right? So you always disclose. Always disclose.
I think on the car forms, there's a subject or an area that exactly specifies, if this, when you put in an offer for a probate listing, if the trustee has full or not full authority on that.
Yeah,
So
I think that's
if they
right.
don't come back with that information, they probably don't know what they're doing.
For sure.
Because, that's basically listed right on the car form.
Definitely. Anyone else?
I have a situation, I know that probably the laws are not the same in Mexico, but my situation is that one of my brothers doesn't want to sign the, what would that be? He doesn't want us to sell the property. He said, no, I'm not signing anything. And according to the attorney over there, he said that we can sell the property without his consent, and all we need to do is not have him, do not give him anything from, is that true? I know that I don't know, it could be a little bit different here than.
So let's assume, well, here you don't need their consent for anything, right? But let's assume an error causes problems, and like that guy that we had to evict, right? If we really wanted to, and because I incurred fees doing that eviction, if we really wanted to, we'll take those fees and debit it from his share, something like that. But we still have to give him his share.
But you still have to give him the share.
Yeah.
For example, my brother's share.
Mm-hmm. You would still have to give him a share. Obviously, if they cause, damage to the estate, then you just deduct it from his share. Yeah. Okay.
So what, I'm a little impacted by this. So are you saying if there's someone of the heirs that doesn't want to sell, but the other, let's say it's three, the other two siblings do, you could still sell and just give him his share?
Yeah. So it would be only up to the appointed administrator. He's the one who decides. Like I said, decides the realtor, decides the price, and price as long as it's above that appraised value, and then he just sells it. He doesn't need approval from anyone else.
Full authority.
Full authority, right?
And what if it wasn't full authority?
If you have limited authority, again, as long as you're selling above that price, and as long as you're justifying the sale, right? Like if the house is a foreclosure and you're getting letters from the bank, the court's going to approve it, right? They're going to just, first of all, the court doesn't really want to do much. Doesn't want too much on its docket. Doesn't want to get too involved. So the easiest thing, and it would be pretty easy to justify the sale, right? Again, if it's a frivolous objection or unreasonable delay, or this person is living in the property and therefore it's causing a delay in the sale, then you can debit the cost and the attorney's fees from that person's share.
Okay, so now, what I'm thinking in my brain here is that if there was no trust or anything, it was just three people on title, and two want to sell and one doesn't, that's a whole different thing.
Yes.
However, if someone dies out of it, this is another reason that's another reason to have a trust.
Yeah. And
it's a loophole too, it doesn't matter if you don't want to.
and so like Linda mentioned, if there's other people in the trust, that would go to right of survivorship, depending on the tenancy, and then those people would get the house, right? And so there's a lot of other litigations involved in probate, like partitions. When two people are on title as tenants in common, one of them dies, obviously that half goes into probate, the other half is the survivor, but there's disputes as to whether it's legitimate, things like that. And so, let me see what other one here. Okay, so these are some of the things that people do to avoid doing a trust, and one of them is adding a person to title, right? Or like I get a lot of people who add their children to title, and that is the worst thing you can do. The worst thing you can do, because first of all, if your house is worth $1 million and you just added your son to title, well, that's gains right there. That entire amount is gains, or actually, if you bought it for $5 million and then now it's worth $1 million, that $500,000 is capital gains. So you technically have to pay taxes on that, right? The other thing is that person is now owner of the property, and so if he gets sued, they can go after his house. And if he wants to sell the property, which I've seen it where the son wants to sell the house and kick the parents out, he has an absolute right to do so, right? And I take on those cases because the fees come out of the equity, right? They don't pay anything up front, and litigation goes on for years and years and years. And so I've had it where kids try to kick their parents out of the house. I've had it where the brother and the sister bought a house, and then the sister's husband was also entitled, but now then the brother passes and the sister's husband wants to take the whole thing. So, we've fought about that, and this is in the tens of thousands of dollars in attorney's fees and cost and so depositions is when you have to interview somebody and it's on the record. Those alone are about $1,500. So it gets really, really expensive when you have to take 5, 6, 7 depots. And then they have to show up to court, and then they do the record there, and that's another $2,000 every day. So adding people to title is the worst thing you can do. And like I said, you just do a trust, and those heirs don't get an interest until the husband and wife or the settlers pass away. All right. The other thing that people do, oh, sorry, you had a question?
Removing someone from title.
Yeah, so that should be easy. If they're willing to sign a quitclaim deed or they're refusing to. Yeah, that should be easy. You just do a quitclaim deed and then they come off title.
It doesn't trigger like a assessment?
It could, yes. It depending on who's being removed and how you're doing it. If it's husband and wife, parent and child, there's no reassessment. If there's some exceptions. If they're joint tenants, then it wouldn't make a difference. If there's tenants in common, which means 50, the interest is separate. If you remove somebody from there, then that person giving half to the other person triggers a reassessment. So there's a lot of things that come about.
Because of Proposition 19, if someone has rental property and adds their child to the rental property, so because later on, if there's a will and trust and they get the rental property, it's going to be completely reassessed, correct?
So you add somebody to your child to title
on rentals.
That's a hard question for a lawyer, I guess.
That.
But however, I do have a Prop 19 person that is gonna come to speak here, and he actually used to work at the assessors for 17 years, and he does a lot of cases. So if you guys want to attend that, he will tell you how to add or take away and how to avoid that reassessment and how you cannot avoid it. So that's why you need to follow me on Instagram.
It's true. There's a lot of different ways, and honestly, if I ever when I get a case, I do a lot of research before I provide an answer, because just shooting from the hip can it's not always right. It'd be a generalization. So, and then so the other thing that people do is they create only a trust or only a will. And the reason I do that is, I don't know if you guys ever seen these ads that say, do your trust for $900 or $600. I always get people telling me, well, I saw this ad, they'll do it for $900. I'm like, first, you don't know what you don't know. And these people are probably not attorneys. And if you get only a trust, then there's many situations that trust is going to be useless, right? Like if you have dementia, or if you need a will, if you need a power of attorney or a medical directive, there's many events that trigger different documents, right? And so having a trust alone, it's not gonna save certain people. Or if you do only a will, right, you end up in probate anyway. And it might be a little bit faster as far as objections and things like that, but you're still going to be in probate. And so it's always recommended to do the entire package, right?
I think what a lot of people don't understand is when you subjugate yourself to probate, is that the court takes quite a chunk of your estate.
Yeah.
And that's just for your estate passing through the courtroom.
Yeah. Yeah, exactly.
Very expensive. It can get very expensive.
Yeah, exactly. A lot of people also think that they can do their probate by themselves. And unfortunately, I've sat in courtrooms where I see the individual who's in pro per representing themselves, and they just let the house go into foreclosure, or they're stuck trying to correct certain things. And I mean, there's rules of ethics. I can't just walk up to the person and tell them what to do, or solicit any advice. But it just sucks when you're witnessing this, and a lot of this stuff is pretty easy to fix. A lot of stuff needs more knowledge and legal expertise to do. So it's very sad when you see that happen. Some people are able to do it, right? But it takes even years and years longer. Mm-hmm.
I would like, if you know this, how would any agent or broker get a probate listing through
Yes.
the probate courts? Or is there something that, I noticed some agents are like masters of just getting these probate listings. I'm like,
Right.
is it the attorney they know, or do they go to court and look at cases? Do you have any idea of that?
Yeah, so I mean, a lot of realtors are just reaching out to attorneys. I get a lot of calls from realtors, say, hey, if you got any listings going, they want to help. A lot of it is just relationship with who you know, right? Like you can go through the document, but that would be pretty expensive. There is a way though that these folks know when a lawsuit gets filed. There's also people who sit outside of courtrooms, right, and file these documents for people. and they're all connected. They're all paid out. They're all bought out somehow. Because right now in LA County, we do e-filing, but a lot of courts, like I think Riverside, you can still do filing in person. San Bernardino, I think it's San Bernardino, Riverside, you can still do filing in person. In those cases, in those courts, you have a bunch of people. They have printers. I mean, they're very sophisticated. They have printers outside. You just email them things, they print it out, and they file it for you, or they take care of things like that. And there's bigger companies that have them, that hire those people, but they're super sophisticated. It's just breaking into that, it's, hitting like a gold mine. But if you know an attorney who you're pretty have a pretty good relationship with, it's always good to get in. A lot of the probates that I get come from realtors, right? So I just return the favor right back to them. So it's very hard. It's very, very hard to
Isn't there like a bar association directory that one could purchase? I think so, because then you can look at their probate, call them instead of
Yeah.
sellers. You should use me for that.
Yeah, I don't know if there's a directory. Where I'm from in South Bay, there's a lot of probate attorneys. They seem to be all on that side. I don't know why, but yeah, I would say just reach out to them, walk into their office, because I get a lot of phone calls and I'm like, man, I'm in the middle of something, I can't talk right now, But if they walk into my office, I kind of connect a person, I have more connection. And I do the same. I walk into escrow offices. I think that's how I met Linda. I walked into her escrow office and dropped off flyers. This was years ago. But you just got to stand out. Just recently. But yeah, you just got to think outside the box. Those flyers that I have a ton of flyers. I used to work with a realtor who used the flyers to go door knocking, and he would get a lot of listings that way. A lot of listings or purchases, because you kind of use that as your foot in the door. Just tell somebody this is for your family, and then people will get interested, right? Like they don't like a lot of people will get bombarded with the same stuff over and over. Like, hey, if you want to list your house, come see me, and you gotta step away from the same thing that everyone's saying and do it a little bit different. And I think it helps, right? And you're providing them a benefit. Definitely providing them a benefit when.
That is a great benefit for the sellers to know.
Yeah.
It's a great cold calling tool.
Exactly. And if you guys ever run into issues, I'm pretty accessible. I usually have my phone with me. Everyone has my cell phone, so I get a lot of calls, but I'm willing to talk to anyone, a few minutes and just answer a quick question, and that usually helps you, get in a good relationship with people, especially if they're in a bind, right? A lot of people think you got to go pay for a consultation. I do a lot of free consultations. I answer a lot of quick questions, so it helps having somebody by your side who's able to answer those questions right away. I see. Okay. So I'm always available. I started dropping off flyers again, just in the area like Southgate and Downey area, because I had stopped doing it for a while, and I started doing it again. And just one day, I picked out 3 new cases, right? And they're really good cases, right? So, and it's all because those cases were sitting there for a while, and these folks didn't know what to do with them, right? And all they did was call me. I answered it right away, and we got into the case, and now potential listings for them, right? So, and they didn't have anybody to talk to, so that's what I'm saying. It's just reach out, and I'm very available. There's no bad questions. Believe me, there's no bad questions. Because I have mentors, and I ask questions sometimes, and as I'm talking about it, and that's all it takes sometimes. You just talk about it out loud with somebody, and then you answer your own question, or sometimes it takes hours to figure it out, and you can just call somebody, right? So just reach out. The other last thing, what people do, what they don't do is update a trust after major events. So what that happens, and I'll be quick on this, if you have an account in your trust, and this account's supposed to go to your grandchild specifically, right? But then you close that account because of fraud and you open a new one. Well, you didn't update your trust because that trust had a account number. And so this new account number is not in your trust, and it's not going to go to that kid. It's probably going to go distributed generally, right? So just because you take those funds, open a new account, it doesn't translate to that heir, that beneficiary.